So Dr. Luca Castellani is with us, and he is a head of United Nations Commissions on International Trade Law Regional Center for Asia and the Pacific, that is the UNCITRAL RCAP, if I'm not mistaken. And as a legal officer at Secretariat, Dr. Castellani, would you like to introduce yourself just to tell us a bit more?
Yeah, thank you. I don't think we need a lot of introduction here. I was before the head of the regional center, and I'm now back in Vienna, Austria, and I deal with different aspects of the law of the digital economy. And I'm gonna talk today about the most recent UNCITRAL product and how it can help to enable paperless trade, which is of course very important. I would also like to spend a few words on how we envisage this to assist with the post-COVID-19 economic recovery. And that being said, I hope that I will leave some time for Q&A. I very much look forward to some feedback. So very briefly, what is more important, although many of you will already be familiar with it, the United Nations Commission on International Trade Law has been established more than 50 years ago, and it's the core body in the United Nations system for the preparation and the promotion of uniform commercial law texts. Many of the commercial lawyers know UNCITRAL because of its work on dispute resolution, especially arbitration. But of course, UNCITRAL has done important work in many other fields, and one of them is, of course, the law of the digital economy. We now call it digital economy, but you will find that we use still the older term, which is electronic commerce law. I don't like to use that term anymore because now it has a connotation often of consumer protection and so on, while UNCITRAL by definition deals only with B2B and B2G transactions. And so it's not particularly appropriate to use electronic commerce. Now, getting to the first substantive slide is just to set the general framework here. Promoting digital trade, what does it mean? We would like to be able to have electronic information available everywhere and anytime. And why? Because we want to reuse and analyze data. We all aware of the fact that those countries that are successful in digital trade do so because they put together three elements: the sound policy decisions, robust technical solutions, and wise legal choices. And as the digital economy is inherently cross-border, from the legal side, it is useful to look for solutions that are uniform, harmonized, that facilitate cross-border data flows, rather than hindering them or creating new obstacles to them. But more generally, we need to have certainty and predictability on legal status. And we have also to bear in mind, and this is important for what I'm going to say today, because a lot of what I'm going to say is about trade financing. Certain business fields are risk averse. So next slide. Which actually means next slide. Thank you. So we are talking about a very specific issue here, but incredibly important. All commercial lawyers are familiar with the notion of transferable documented instrument, which the civil law tradition is called something like documents of title, although this in English has limited meaning. What are they? These are paper-based documents that allow the holder to request the payment of a sum of money or the delivery of goods. Bill of lading is the classic example. Check, you see on the screen, bills of exchange, promissory notes, warehouse receipts, maybe letters of credit. The qualification of the documented instrument as a transferable one depends on the national law. These are important because they are useful. Very useful in transport, of course, but because of the possibility to use the cargo as a collateral for financing. And in fact, basically these documents are used in trade financing. They allow, of course, banks to get a pledge or otherwise use the goods as a collateral. This has been so for many years. We know trade financing is a huge market. But if we look at it from a different perspective, from the paperless trade perspective, we also know that these documents have the best quality information about the commercial transactions. They have to be very accurate because otherwise the bank will not give credit. As the problem is that their use traditionally presupposes the existence of paper and possession, which is a physical condition, the ability to exclude others from interaction with a tangible good. So the question is how it is possible to transpose these documents in a dematerialized environment and use them in electronic form. Next slide, please. In 2017, UNCITRAL adopted the text that aims to address this issue, the model law on electronic transfer records. And it is actually the most recent text that UNCITRAL has adopted in this field. There is a dedicated web page on the UNCITRAL website, which is uncitral.un.org. Next. What are the main features? Well, difficult to say in 1 minute, but the most important thing is that all UNCITRAL texts, they are not regulatory or prescriptive in nature. This means that we are not creating new requirements. We are trying to address the legal problems that are in existing law. And we do so by using the functional equivalence principle. The functional equivalence principle allows to set up those conditions that need to be fulfilled so that an electronic document will be equivalent in function to a paper-based one. One extremely important consequence of this is that the same substantive legal regime applies to paper and electronic. So there is absolutely no special regime, for instance, for an electronic bill of lading or a separate one. The law of bill of lading in a certain jurisdiction will be identical regardless of the medium used. The model law, like all UNCITRAL texts, is technology neutral, although the explanatory note does have some comments on how implementation may be envisaged when using a distributed ledger technology. And the main features of the model law with respect to functional equivalence are singularity, that is to say, although we know uniqueness is impossible in a dematerialized environment, we want to make sure that there is only one electronic transfer record corresponding to a certain transaction to avoid the double spending problem. Control, that is to say, we want to make sure that possession is transposed in an electronic environment so that the person that is actually disposing of the electronic transfer records by endorsing it, by transferring it, or by requesting performance is the one who actually is supposed to do so. And then integrity, that is to say, we want to record all events that are relevant for the life cycle of the electronic transfer record. Next slide. I don't want to go into the legal details, and I want to go rather have a discussion on what is the business impact of this. We know and we have seen that there is a huge demand for pushing further dematerialization of commercial documents. For instance, some of you may recall the bank payment obligations. They came out of the need to accelerate the confirmation of process of confirmation of letters of credit by banks, because sometimes, for instance, in East Asia, the carriage of goods by sea itself was shorter than the time that was needed for the bank to confirm the acceptance of the letter of credit. But if we move everything electronic to an electronic environment, we don't transpose each step. We want to re-engineer the whole business process and also to adapt it to the current reality. For instance, here there is an example. If I issue a blockchain-based bill of lading and I provide enough evidence to the regulator that this is according to certain security standards, then the regulator may accept that the electronic bill of lading is like a paper-based bill of lading, and this helps me in reducing capital requirements for financing under the Basel III Accord. But most importantly, the vision here is that there is one commercial transaction and there are tens, hundreds maybe, of commercial documents and regulatory documents. But in the electronic environment, it doesn't have to be. In the electronic environment, we can get back to a single electronic record. Next slide. This electronic record will contain all the trade-related data that pertains to that transaction. So it can replace all commercial and compliance documents. And then, of course, the information will be shared selectively depending on who needs to get that information. This is an implementation of the concept of data pipeline that allows to integrate all the data elements in a single supply chain. And the huge advantage of this is the quality of data, because if we have a single electronic record, we have the highest assurance that this is updated, it's complete, it's accurate, and it's authentic. That is to say that the originator is the one that purports to be the originator. This is being implemented, as we will see shortly, because it's a vision that allows to create a national trade platform where there is a single ecosystem for logistics, finance, and also customs and other regulatory issues. Those customs and regulatory issues are now taken care in national single windows, but we don't have a single space for logistics and finance in most countries. Next. So what is happening with the enactment? The model law is very good, but of course we need to see it in action. Well, you see here the link, as I mentioned, so everything is on the UNCITRAL website, and so the slides will be shared and it's possible to access this material. It's important to bear in mind that at least 100 states have already adopted one or other or several UNCITRAL texts on e-commerce. The model law on electronic transfer records, MELITA, as we call her, with an endearing term, is enforced in Bahrain. And there are several other countries, considering the most important one being Singapore, that has already announced the adoption of MELITA to legally enable trade trust. Trade trust is the national trade platform that will implement the vision I mentioned before, merging the national single windows for customs operation and the trade financing and banking and logistics platforms for B2B exchanges. So this is particularly important. Trade trust, I believe, will be blockchain based. But of course, as I said, MELITA is technology neutral and there could be other ways to implement it. And also very important, there was a very, very strong interest of the International Chamber of Commerce for MELITA for post-COVID-19 recovery. And now we are partnering with the ICC Digital Strategy Initiative to promote the model law together, and especially to make aware both business and legislators and policymakers of its benefits. Next. A few words on an illustration on how MELITA can help in mitigating the disruption coming from the pandemic. Of course, if we move to paperless trade and paperless operation, we are minimizing the risks and the delays arising from personal interaction, not only in terms of spreading, but also in terms of, for instance, not having staff able to perform the functions, or either because unfortunately they cannot be there, or because they would be exposed to a risk that we don't accept. Of course, if we have the whole paperless trade chain electronic, we also have the full view of what's going on, and we can respond faster to needs. We can prioritize delivery of important shipments, critical shipments, give, for instance, a fast track to sanitary and humanitarian shipments, and while the others can be put aside. But this has to do with logistics, of course, but of course there is also the other side of trade financing. So if we have this comprehensive environment, we can lower, for instance, compliance costs. We can better assess the risk of financing. We can reduce also the labor cost itself in processing the documents. And we trust that this will be very useful to give better terms for access to credit, in particular to SMEs. Next. For those particularly interested in seeing how this can be transposed into reality, there is a project at UNCITRAL. CIFEC is, of course, a forum of the United Nations Economic Commission for Europe, but it's a global forum that puts together business. It's particularly business oriented. And so there is a discussion on how Melita can be implemented. There is in particular interest for the LTM blockchain, but in general, and a discussion on putting together the law and the technology and see what would be the requirements in technology to satisfy the legal ones. And next. We are finished. This was the last one. So I'm very happy now to take the Q&A, and I hope that this was useful and clear enough.
Yeah, absolutely. Thank you. It was an incredible presentation. Luca, we've actually met a while ago when you visited Slovenia and gave that presentation to legal hackers. We invited you to speak at the premise of European Blockchain Hub at that time. It was quite a while ago, so I'm curious, how much has changed? Are matters something that changes over time, or is it really the text stays the same and it's up to the countries to implement it the way they want, and they are the ones thinking about how the reality has shifted since then?
Of course, the model law itself has stayed. What has changed since we met almost a couple of years ago is that back when we had awareness only in our environment, which is of course important, but we had to reach out to business. And now, and partly because of the pandemic issue, which is very unfortunate, but it has accelerated digital trade a lot, of course. Mm-hmm. Now we have a lot of interest, especially from as I said, the ICC, but also others. And also we have made a lot of progress with respect to practical implementation of this. So what is happening in Singapore, I spent a bit of time to describe that, because that is really a comprehensive and integrated approach. And Singapore intends to adopt, but to implement right away. And to implement it is necessary to have the ecosystem. And the ecosystem is being developed. So to adopt the law itself is comparatively simple, especially in a country like Singapore that has already adopted all other UNCITRAL texts on electronic commerce. This can be done very easily, and it's not the only country in the world. Mm-hmm. But the implementation, of course, requires the technical infrastructure, and then when the technical infrastructure is done, there is a need to have all the stakeholders on board. So here we are talking about three main stakeholders: the public sector, mm-hmm. and of course, we say customs because customs usually are single window operators. But customs are single window operators on behalf of the different government entities. If I remember correctly, depending on the transaction, in Australia, there are up to 70 government entities involved in import-export, and in the US, about 100. Now, some of them are involved only for certain types of transaction. For instance, someone will take care of radioactive material and it will be the national agency for that thing. But, you know, or someone will take care of cultural goods. And so, you know, and it has to be something like that. So it's not that all of them are involved all the time, but some of them are involved all the time, like the statistical office. So that is complex. When there is the banking sector, which is regulated, so in a way it is possible to put bank and financing operators together, but it's broad at the same time, and there are a lot of interests. And then there is all the logistics parts, and that one, although as a matter of fact, air carriers and sea carriers are a comparatively limited number. But of course, freight forwarders and road carriers are thousands and thousands. And that one is not really regulated. I mean, it could request a license, but it's not easy to put them together. So, and then of course, there are also issues of deploying these in a way that is in line with antitrust rules, that does not advantage big players. One thing. So in reality, maybe the legal part was missing, but now the legal part is the easier part. The technical part is somehow challenging, and the business part is really challenging because there is the need to put everyone together.
This is so interesting.
But we see actually some business operators who are actually offering services in, especially blockchain based, on electronic bills of lading or electronic promissory notes, who actually say they are compliant with the model law, even if the model law has not yet been adopted in their jurisdiction. Because this has become a little bit as a way to say, yes, we trust the model law, and we want to give some assurance to our clients about the model law compliance, so that they know that it's legally enforceable and it's done in a certain way.
Thank you so much. That was an extensive answer. Perhaps John Haskell has a question or maybe a comment. Dear Dr. Castellani, I believe your degree was originally in law from Torino. I occasionally teach in Torino, and not only one of the more beautiful places in the world, also very intellectual, aesthetically rich ecosystem. Would also be interested in your suggesting as a policymaker, what you find most interesting to hear from my university professors. For example, what sort of scholarship to thought development do you think are most useful?
Well, I mean, first of all, many thanks. Yes, I was born in Torino. I moved out a while ago, but Torino is one of those places where once from Torino, always from Torino. So, and once in Torino, always from Torino as well. So it's a very inclusive place for those who actually feel the attraction. Thank you so much. I believe university professors should really do what they are best at, that is to say, to provide the level of intellectual input that is totally outstanding, and it's also free of any practical consideration, if you wish so, because sometimes vision is the best way to move forward. And if I may speak, of course, not as a UN staff, but that I actually, we never speak as UN staffs, of course, officially, but not on things related to the UN, but of things related to the fact that I also like to teach, and I teach every year. And I would like to say, if we are talking about certain countries, it's important to find a balance in between providing very good quality teaching and also for some honing the research skills, while at the same time there is a problem of volume. In many countries there is this discussion going on about what is important, the quality or the quantity of the students. And of course, since I belong to an older generation, for me quality is important. And so in that ongoing discussion, I would say, yeah, quantity matters, but quality prevails. That's my personal opinion. And Anya, if you don't mind, I would like also to answer the previous question, which is about repudiation of electronic signatures. Now, the rule on functional equivalence, UNCITRAL rule on functional equivalence of electronic signature says that there must be a reliable method to identify the signatory and to link the signatory and the message. But I think that this is a question of repudiation of electronic signature is a question that many times is a bit exaggerated, because in many transactions there is not just the electronic signature. There are a number of other factors. So if we have the signature itself, we have, of course, multi-factor authentication. For instance, I buy online, I pay with a credit card, and then I am asked the little number on the back, or I am asked to do something. Okay, but that we have also to see what is the type of transaction and what is the amount. Sometimes we have, for instance, well, not sometimes, we always have algorithms that can block a transaction of a certain type or with a certain region or in a certain time, and so on and so forth. So, but for other types of transactions, which are B2B transactions, usually people meet in person, then send messages, then send emails, then send kind of things. And I have seen this argument of non-repudiation coming up very seldom. But usually the judges don't accept it. There are cases, for instance, from Australia and from Singapore. They say clearly, no, we have so much evidence outside the electronic signature, but it is unlikely that now there is a problem with attributing the message and with saying that the signatory is not the one indicated in the message. And we are talking about here signature in a very loose sense. So it can be also the name in a chat group. You know, now we have this discussion about signing a contract with an emoji. So, and so you can have a pseudonym and it's all valid because this is how business is evolving. So I would say, yes, there is a lot of literature on that, but at the same time, it's a problem that is of interest for the policymakers, but a bit less so in practice.
That is incredible. I have one final question, and then we can perhaps conclude, but what would you advise, since future law's agenda is to actually find out what negotiating the new normal is through collaborating and inviting a lot of these legal professionals, including the activists, including everybody who's basically interested in having the bottom-up legal change being co-created. Do you have any advice, knowing that you have been working with these agencies, that now you are inviting businesses more and more? How do we foster this collaboration? How can we do that on a global scale?
Well, I can speak only for the law of the digital economy. And I think that what is going on also on an intellectual level around the WTO Joint Statement Initiative is important. So if someone wants to focus on what could happen there, but we have also to bear in mind that we have gaps. There is a divide. It's not just a digital divide, it's also an intellectual divide. Different parts of the world look at the digital trade in different manners, and these may end up creating serious problems, because there will be data flows and there will be access to different types and levels of services in different parts of the world. So I would say, yes, let's have this discussion on what the solutions may be, and at the same time ensure that everyone is on board, because there is a huge issue, in my opinion, with involving different parts of the world. It's not just a matter of technical infrastructure. It's really a matter of familiarity with business processes and getting over certain legal notions that were good 100 years ago, 500 years ago, but now it's the fourth industrial revolution. We have to accept it.
Thank you so much. This explains a lot. And I think, or I believe that you actually provided us with some directions into what we might be addressing in the future, or at least when we are creating these network communities of practice of all the people that are willing to help and explore these topics together. Any final comments?
Thank you. Thank you so much. And you know how to contact me. I'm at your disposal and at disposal of the people attending this great session. Thank you.
Perfect. Thank you for sharing the presentation with us.